Hi, my name's Tom. Thanks for coming out this afternoon to hear this talk. This talk is about the border search exemption to the Fourth Amendment's probable cause requirement. This has been a topical issue in the past few months, and I'll explain why it has suddenly become something that a lot of people are talking about. The simple sort of executive summary is that U.S. Customs is randomly searching the contents of electronic devices at border checkpoints, laptops, cell phones, PDAs, digital cameras. You may be asked to reveal your encryption key. Sometimes items are seized and they're returned without explanation weeks or months later. The Association of Corporate Travel Executives, which is a lobbying group that lobbies for the interests of business travelers, surveyed their members, and they had 100 members respond to their survey. And of those 100 members, 7 reported having electronics seized at the border. On the Customs website, it says everyone is subject to an inspection when they arrive in the U.S. There was a Senate hearing about this a few months ago, at which Peter Swire, who's an attorney at the Center for American Progress, said this issue may mobilize the reserve army of outraged techies. So I was randomly searched at the U.S. border once. I was flying into the U.S. from Australia, and I flew into LAX, and there were some guys out there that flagged me and my sister. I'm pretty sure that we were randomly selected because after they flagged us over, they kind of said, well, I think we've got enough, as if they had some sort of quota they were meeting, and by selecting us, they'd reached that quota. They went through my bag. This was about 10 years ago. And, of course, they go through the bag, and for every sock and piece of underwear or whatever you have in your bag, they hold it up and they say, is this yours? Is this yours? Is this yours? So, after about 20 or 30 items, you kind of get lulled into this sense of security, and you simply say yes without really paying attention to what it is they've held up in front of you. And this puts them in a position where they could hold up a bag of weed that they grabbed from under the table, and maybe you wouldn't notice before you'd already admitted that it was yours. So I came away from this experience a little frustrated. I was frustrated that I'm a U.S. citizen and I'm on U.S. soil, and I was randomly searched by U.S. law enforcement. And I was also frustrated by the way that they asked the questions and the way that they searched me. It seemed like it was sort of designed to entice me to make a false confession. So in any event, I went home and did some research. And the first thing that I learned, the number one item on their frequently asked questions list at that time was, why did you seize my Beanie Babies? Beanie Babies were quite popular about 10 years ago, and there was no internationally licensed distributor for them. So people would go overseas and they would find Beanie Babies, and they would buy them, bring them back into the States. They would be randomly selected for search, and the Customs Department would seize their Beanie Babies. And so I want to keep this in mind. Customs does have a very important role to play in fighting terrorism and narcotics trafficking, but a large majority of what they do is trade protectionism and intellectual property defense, and it's important to keep that in mind when you're weighing the importance of some of these rules against your civil liberties. So the other thing I learned is that the Fourth Amendment doesn't quite work the way that I thought that it did. This is the Fourth Amendment. The right of people to be secure against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. So it turns out that the Fourth Amendment is read by lawyers as two different clauses. The first clause says that the right of the people to be secure against unreasonable searches and seizures shall not be violated. And the second clause says if you want to get a warrant, you have to establish probable cause. But there's no part of this thing that says when you have to get a warrant or that a warrant is required for a search to be reasonable. So my assumption that a warrant is always required is not true. And there are a number of contexts where a warrant is not required. The border is a context where no warrant is required. The U.S. Supreme Court said in 1977, searches made at the border are reasonable simply by virtue of the fact that they occur at the border. So no unreasonable searches, but any search we perform in this place is by definition reasonable. So they are upholding the Fourth Amendment, but it doesn't provide you with much. Another case in 1985, routine searches of persons and effects of entrance are not subject to any requirement of reasonable suspicion, probable cause, or warrant. So they use this term reasonable suspicion. And this was actually very important in this 1985 case, so I'll talk about it. Routine searches can be performed at random at the border with no individualized suspicion. However, a search that's non-routine requires some sort of reasonable suspicion. They can't do it at random. So the question, what does that mean? What is a non-routine search and what is a routine search? There are two court cases, and we'll talk about them both, that kind of are closing in on a definition of what the line is. There's this lawsuit from 1985 where they said a search of a traveler's alimentary canal is a non-routine search. And so they have to have probable cause in order to handcuff you to a hospital bed for 3 days, hoping that you'll eject cocaine-filled balloons. On the other hand, there was a case from 2004 where they took someone's gas tank off their car and disassembled it, and that was viewed as a routine search. So on the one hand, we got gas tanks, on the other hand, we have alimentary canals, and there's a lot of, the argument is about where the line is between those two things. So here's the other thing is, what is reasonable suspicion? It's not probable cause. Probable cause is a pretty high bar. Reasonable suspicion is a very low bar. Here's an example of a court case. This suspect arrived from Colombia. She was traveling alone. She had only one suitcase and nothing to declare. She was young, clean looking, and attractive, and she was wearing a loose fitting dress. That was reasonable suspicion. They searched her. Turned out she had some cocaine taped to her abdomen. And it was upheld. So a very, very loose standard. Here's some examples of reasonable suspicion. Suspect was first to the plane. Suspect was last to the plane. Suspect deplaned from the middle. Suspect had one-way tickets. Suspect had round-trip tickets. Suspect was on a non-stop flight. Suspect changed planes. Suspect was traveling alone. Suspect was traveling with a companion. Suspect acted nervously. Suspect acted too calmly. So pretty much reasonable suspicion means whatever the hell they want it to mean. And mind you, if they can establish reasonable suspicion when you come into the country, they can handcuff you to a bed for 3 days. The key legal question that's going on right now is, do laptop searches require reasonable suspicion? I'm going to read this slide backwards. The first question is, reasonable suspicion is such a weak standard. Well, who cares? There's two important differences. If reasonable suspicion is required to search a laptop, then they can't do it at random. They can only do it when they have some reason to do it. They have to come up with a reason. They have to care. The other thing is, they can't do it to everybody. The way if reasonable suspicion is not required, then let's imagine hard drive duplication technology improved tremendously, and it was possible to image someone's hard drive very quickly. Then it would be economically feasible for them to bring everyone through and just have them set their laptop down, and they'll zap. We'll get a copy of it, put it in our database, and you go on your way. That, under the law, that as the Customs Service is arguing it should be, that would be perfectly legal. They could do it to everyone coming in the country. So that's something we need to keep in mind, and we need to think long-term into the future about what the implications of this policy are when we decide what side we want to take in this debate. There's this case from 2004, the gas tank case, and I talked about it earlier, and I said, is a search of a laptop more like searching a gas tank or more like searching an alimentary canal? Some people think, well, if you got to take someone's clothes off, then it's definitely a violation of their privacy that's different from a normal search. And so we'll put that over here. But a laptop is just like any other piece of luggage. And so it's a physical object. It's property. And so it doesn't require reasonable suspicion. That's where some people draw the line. In my view, you don't have a lot of personal privacy interest in your gas tank. I don't know about you, but my gas tank has gas in it. So the idea that the cops are looking into it, I honestly don't like the idea that that's considered a routine search, but it's really not like a huge problem. However, if you go through my laptop, I've got all my personal correspondence in there. I've got all my, all my writings. I've got software archives going. I've got personal work archive going back years. All kinds of really personal, intimate stuff. I got pictures of my family and friends from vacations. These are not things that I obviously am more protective of the contents of my laptop than I am over the contents of my gas tank, and so I think there is a difference. Before I get into, there's actually a lawsuit that's where this issue is being litigated. But before I get into it, I ask whether this whole legal framework about reasonable suspicion even makes sense. In 1985, that was the first time they said routine searches do not require any reasonable suspicion, and they justified it with this footnote. And they said, see this case from 1977 called U.S. versus Ramsey. So you go back and you look at this case, U.S. versus Ramsey, and it quotes, it says, the Congress which proposed the Bill of Rights, including the Fourth Amendment, to the state legislatures in 1789 had, some 2 months prior to that proposal, enacted the first customs statute. This statute granted customs officials full power and authority to enter and search any ship or vessel in which they have reason to suspect any goods, wares, or merchandise are subject to duty shall be concealed. And so the court says, well, because in 1789, the guys that passed the Fourth Amendment felt that the Customs Service should be able to search people without a warrant, it's okay for them to search people without a warrant. But it seems clear to me that the first Congress felt that the Customs Service should have reason to suspect that the things that they were searching contained some contraband, and this is not an authorization to search at random. However, in 1985, the Supreme Court said it's okay to search at random, and this is why. And I don't buy that. That doesn't follow for me. However, there's this lawsuit, U.S. versus Arnold, which is currently going on. On July 17th, 2005, this guy, Michael Arnold, arrived at LAX. He was selected for secondary screening. He said he was visiting friends in the Philippines. He had a computer. They booted it up. They started looking at it. He had 2 folders. One's Kodak pictures and the other one's Kodak memories. The agents clicked on the pictures and they found a picture that depicted 2 nude women. Now, there's actually a footnote in this ruling that says that Customs hasn't established that those 2 nude women were not adult women. So as far as anyone knows, this was just porn. In any event, they called over the Customs Service. The Customs Service went through the laptop, and eventually they found child pornography. So, and again, it's important to understand that, for every one of these really bad guys that gets picked up, there's a bunch of other people who've been searched, but they don't get to go to court. Because they're never charged with anything. It's only the guys who are really bad who end up in front of a judge, and then you have an opportunity to litigate whether or not the search that was performed against them is reasonable. And so, unfortunately, when you're trying to defend people's civil liberties, you sometimes have to take the side of really bad guys. And this guy is not necessarily a good guy. We don't like him in general, but the fact is that he was in a position where he was subject to a random search without any establishment of reasonable suspicion, and so the question is, was that right? Irrespective of who he is and whether or not he ought to be prosecuted in general. So there was a ruling in 2006, which I was very optimistic about, from the Ninth Circuit Court, which says that this gas tank case acknowledged that there were cases where significant privacy interests were at hand, and it simply said the gas tank isn't one of those cases. But the laptop, they said, is one of those cases, and so reasonable suspicion is required to search a laptop, and I was very optimistic about that. However, and this is why this has become an issue right now, in April of 2008, the Ninth Circuit Appeals Court came down with an opposite ruling. Essentially, they overturned the district court. They said that we used to have this privacy intrusiveness analysis for border searches, but because of Flores, Montana, this gas tank case, we can no longer do that, and therefore, reasonable suspicion is not needed to search laptops. There's a couple reasons why I don't like this Ninth Circuit ruling. It is currently the binding ruling. The first is that this gas tank case was specifically about vehicles. They say, complex balancing tests to determine what is a routine search and an intrusive search have no place in border searches of vehicles. But they leave open the question of whether there are other contexts where it might make sense to have an intrusiveness analysis. And this court just sort of glosses over that fact and acts as if it generally applies to property. And you see that same sleight of hand in Wikipedia, where they actually replaced the word vehicle with the word property as if they were synonymous in their summary of this in Wikipedia.